So guys, here we have gathered to study about this subject constitution, right? If I have to talk about this subject, it is nothing but a document of law, right? And before we delve into this subject, there are two concepts. Firstly, I'm going to talk about one is about society and the second is about state. By viewing the understanding of these two topics, we will be able to understand this document of law in a more greater way. Okay, so first topic, taking society and linking this concept of society, that how in this society this document of law developed over a period of time. I have divided the understanding in two stages. I have divided this society in two parts. One is, I call it to be a static society, and one I'll call it as progressive society. Okay, now the understanding of law per se developed into this society in seven stages. Okay, that the understanding and the law itself developed in this society in seven stages. One by one, we are going to talk about that in detail. Okay, the society, I divided it into two parameters. One is static society, one is your progressive society. Now to understand how the law developed in each stages in the society one by one, let us go through with a story. In the initial stage, in the first stage, we all know, we all have to go to the ancient times where there was king. Okay, king, he used to rule over a boundary or certain area, and whenever the people of that area was facing difficulty or was facing injustice, they used to approach this king for justice, right? So the first stage of development of law happens in the society likewise only, where there is king and king delivers the justice to the people of that place. Okay, in Roman philosophy, there is one concept, that is, there is one goddess. The goddess name is Themis. She is the goddess of justice, and it was believed in the Roman system that this goddess Themis sits on the tongue of king, and through the medium of king, she delivers the justice to the people. So today also, if we have heard, there was one very known phrase that king represents God. This was the belief in the ancient system, that this king represents God. So that was the initial and first stage of development of law which happened in the society. And this development, this first stage of development of law in the society happens in a similar way in static society also and in progressive society also. Okay, this is the first stage of development of law in the society. Now what happens is, from this first stage we move towards the second stage. Now there is a development of customary laws. Customary laws. Okay, in the society, both in static society and in progressive society, the second stage of development of law happens as a form of customary laws. Now to understand that, you can understand it likewise. For example, in any matter, king gave some decision. Okay, king gave some decision which was adopted as justice to that people. For, let's say that if any person steals anything, he will be punished, for example, for 1 year. Okay, or to take an real example, in Arab countries there is a punishment which is, if anyone steals, his hand is cut down. Okay, so now what happens is, this decision which was given by the king, now over a period of time, the people, common people of that place knows about that this particular matter have this particular mode of justice. So among themselves, using that customary practice of law, they can decide among themselves. Okay, previously in this similar matter, king gave this decision and it knowns to be a similar matter. Now among themselves, they can decide that, okay, this will be the form of justice for that. Okay, so this was the form of customary laws which developed over a period of time. Okay, so this was the second stage of development of law in the society, and it happens in the same way both in static society and in progressive society. Okay, so here I have divided it to be called as static society and progressive society. Okay, so wherever I write this S and P, that means This first stage is similar in static society and in progressive society as well, both ways. Okay, so this second stage of development of law also happens in the static society and in progressive society in the same way. In the third stage, what happens is, now there are ministerial system introduced in the court of king. Okay, ministerial system. We have heard many very famous ministers like Birbal was there in the court of Akbar, right, etc. So there was a ministerial system which was introduced, who used to do what? Who used to guide the king in the matter of justice. In the matter of justice. Now these ministers, either in a positive way or in a negative way, according to their understanding of the law, they used to influence this king, or you can say guide this king in reaching to this agenda, that was justice. Okay, so this ministerial system was nothing but a seed of lawyers which was feeded, you can say. This was the third stage of development of law in the society. Today also, when we see the role of lawyers, okay, if I have to make a picture of the court in front of you, you will find that here judge sits. Okay, here judge sits, in front of him the lawyers from petitioner, the respondent side, right? They stand here, lawyer 1, lawyer 2. They guide the judge in their own way. They guide, both the side guide the judge to reach, to deliver the justice, right? So similar was the form of the ministers in the court of king. Okay, so they used to guide the king to reach that justice. Okay, so this was the third form of development of law which happens in the society, and this happens similarly in the static society and in progressive society in the same way. Okay, then from this we move towards the fourth stage. Okay, the fourth stage of the development of law which happens in the society is in the form of codification. Okay, what is codification? Today we understand the codified laws such as IPC, CRPC. These are what? These are the codified law, like Hindu law. These are all codified laws, okay, which we understand. Now, initially, what was this codification? The term meant was there was distributed laws. Okay, for example, and let me say to you this stage, the third stage, had a huge influence on this fourth stage, that was codification. Why? Because now, as I told to you, these ministers used to guide the king, okay, to deliver this justice. Now, imagine there was some situation where one person was close relative to this minister. Okay, now if he is close relative to this minister and he is there in the court of king, and of course he will use his influence on king to make a lesser punishment or less harsher punishment for this person. Okay, and in a similar matter, when this person who is not related to this minister, in this matter the impact was different and he used to get a different justice. Okay, so this was the scenario where in the same matter one person is getting a lesser punishment, and in one matter one person is, in a similar matter, a person is getting a cruel punishment or harsher punishment because he was a relative of minister or not. So this ministerial system was having, in the public, they was having this dispute, they was finding it to be unequal among themselves. So there was this equality was missing there. In that scenario, the demand for codification started among the public, and they demanded that there should be a codification of laws. That means all the laws written at one place. Okay, and now if any person, if he is rich or poor or any class of person, commits that matter, and accordingly whatever is written, he will be delivered or he will be punished. Okay, this ensured what? Equality in the society, that for any type of same matter, if any person from any class of the society have committed that particular wrong, he will be delivered with the justice in the same way. Okay, so this was the codification stage of the development of law in society, and this happens in a similar way both in static society and in progressive society. Now till this stage of development, that is this fourth stage of development, this is same in static society and in progressive society. Okay, now the development of law stops at fourth stage in static society, that is with codification. Okay, it does not move further. The development of law in the static society does not move further from this phase of codification, where in progressive society we see the fifth stage also we see, the sixth stage also we see, the seventh stage also. Okay, now let us move toward the fifth stage of development of law in the progressive society, in the society now. Now, as I said, this fifth stage only happens in this progressive society. Now, what is this fifth stage? Here we introduced certain fictional concept or fictional character. Okay, for example, one fictional character is person. Okay, if we go by the definition of science, this person should be a living being. Okay, man, male, female, whatever we can identify through science. But through law, we also term this person to something which is company, which by science is not a real person, right? If we go by science, this person is not a real person. But when we go by law, this fictional character which was introduced, by which we also accepted this person, this company, to be called as person. Okay, and also in Ayodhya case, we accepted, we denoted the idol of Ram, idol of Sri Ram, as person, right? Also, Guru Granth Sahib is also treated to be a person, even though in the real interpretation, that is one murti, that is the idol, that is the statue, that is a book. Okay, but when we go by the definition of law, we use the term person to interpret them also as a person. Okay, so by this fifth stage, in this fifth stage, we introduce this concept of fictional characters. Okay, and it happens in the progressive society. By this we move towards the sixth stage. Okay, and in sixth stage we introduce the concept of equity in the society. Okay, in the progressive society. Now what is this concept of equity? That means not equal distribution. If I go, there is a difference between equality and equity. Okay, in the sixth stage the introduction of equity happens, while when we saw equality, we saw this happened in which stage? Fourth stage. By the codification, the what we ensured? Equality. Okay, now what is equity? See, equity is that there should be fair distribution. Okay, to ensure the fairness in justice, we introduced this concept of equity in the court. Okay, now for example, to understand equity, we can take this example that this is a wall. Okay, beyond this wall there is a ground, and there are three persons standing. Okay, one is enough heighted, okay, to see the match directly, one is little bit short heighted, and one is very short heighted. Okay, and we have, in resources, we have three boxes: box 1, box 2, and box 3. Okay, and to apply equality, that means one box given to each person. Okay, that will ensure equality, but that will ensure fairness or not? It will not, because the first person does not require any box, because without box also he is able to see the match beyond the ball, right? By equity we ensure fairness. How? Because this person, second person, needs one box. By giving him one box, we will ensure that he is also able to see the match beyond the wall, and by giving this person two boxes, we will ensure that this person also able to see the match beyond the wall. So this is the concept of equity, by which we ensure the fairness in justice. And let me say to you, this our Supreme Court is also a court of equity, is also known as court of equity. Okay, to deliver complete justice, the Supreme Court can apply the principles of equity as well. Okay, can apply the principles of equity as well. Okay, now one second. Okay, okay, now as I mentioned, we understood society. Okay, we understood society into two formats: one was static society, one was progressive society. Okay, and till now, if I can add people beyond this, give me one second, guys. Okay, okay, So what we discussed was 4 stages happens in this static society, and we discussed 2 stages which happens in progressive society. That was equity, and that was fictionalization, and that was equity. One more stage which happens in the progressive society is legislation. Legislation. Okay. Now what is this legislation? See, it was the 7th stage of development of law which happens in society. Okay. With this 7th stage of development of law which happens in society, we introduce legislation. And what is legislation? See guys, legislation is nothing but law making machine. Law making machine. Okay. Now, whenever with the changing circumstances in society, we want a new type of law to be introduced in the society, we can go to this machinery which is legislation, through which we can pass the bill and we can get that law. Okay, so that is legislation. And when I denote this legislation, I use this term for 2 things. One, we have union legislation, and one we have what is state legislation. In union legislation in India, we have which is called as parliament, which the form of legislation we have is parliament. Okay, parliamentary legislation. In parliament we have Lok Sabha and Rajya Sabha, right? Lok Sabha is known as lower house, and our Rajya Sabha is known as council of states, right? Council of states. Why we call Lok Sabha as lower house? Because every 5 year this house dissolves. Every 5 year this house dissolves. And Rajya Sabha, we call it council of states, and it never dissolves. Never dissolves. Okay. And on the other hand, at states we have legislative assembly and legislative council. Similarly, right? Legislative assembly, every 5 year it dissolves. Okay. Similarly, we introduced this concept of legislation. Okay. So what we discussed till now, we understood which was society. To understand this society, we divided it to static society and progressive society. In static society, we understood 4 stages are there, and in progressive, we understood 3 more stages are there. Okay. In total, in progressive society, 7 stages happen, and in static society, the development of law stops at this 4th stage, that is the stage of codification. Okay, but in progressive society we see from codification 3 more stages happens, and it ends till legislation. It ends till the body which is legislation, that is the development of law which happens in the society. In the introduction, as I said, this constitution is nothing but a document of law. A document of law. Which type of law, which type of document it is? It is supreme law, a supreme document of law. Okay, a little bit later, after discussing one more concept with you, that is about state, I will come to the discussion of this supreme law with you. Okay, I believe that you have understood what is society. From this society, we understood that legislation is the body we created in the last phase of the development of law in society. Now from that, let's move to the understanding of what is state. Now here, of course, 2 ways of understanding are there. One is with the perspective of international law. What is state? We are going to understand it in the perspective of international law. And under Article 12 also in the Constitution, we have the definition of state. This part we are not going to do right now, because when we are going to cover Article 12, what is state, we are going to understand in detail. The objective right now to take you forward in the understanding of the concept, we are going to understand the state from the point of view of international law. See here. Now, according to international law, the definition of state is containing 4 things. One is population. Okay. Now, to have a state, according to international law, there are certain essentials which are required. Okay. One by one, I'm going to list it here. Okay. One is population. The second is permanent boundary. Okay. That is permanent population is first thing. Permanent population. The second is boundary, that is territory. The third is having government, and the fourth is being sovereign or sovereignty. Okay, so these are the 4 essential elements of the state. Now, if I just take these 3 elements, that is permanent population, that is territory, that is government. Something which I form is to be called as society. Okay. When I add this society with sovereignty, something which I form is state. Okay. Society we have understood. Okay. Society only contains three things, that is permanent population, territory and government. Example, Palestine. Okay. Palestine has permanent population, Palestine have territory, Palestine have its in that's internal government. Okay, what it does not have is sovereignty. Okay, for which it is fighting. Now, when I add this sovereignty with this society, I reach in the definition of international law to statehoodness. That is to state. Okay. Now to understanding constitution, the state understanding of state is very important. What I just mentioned is sovereignty. Okay. And society. Now what does sovereignty does is, this sovereignty does very interesting thing, that this sovereignty binds this society by making of supreme law, by making of supreme law. And what I mean by this supreme law is, see again, I'll place it here. What I said is, this sovereignty do what? Binds society. How it binds the society? By making supreme law. Supreme law. Okay. And by making supreme law, it ensures all other laws will flow according to this supreme law. Okay. And if this other laws are against this supreme law, it will be declared void. It will be declared void. Now we will come to this again by understanding one interesting concept, that is pure theory of law. Pure theory of law. This was given by Hans Kelsen. One jurist, his name was Hans Kelsen. He gave this theory, pure theory of law. I'll come to this point again once I complete the explanation of this pure theory of law. Pure theory of law. Okay. To understand this pure theory of law, I'll draw a pyramid in front of you. Okay. By drawing this pyramid in front of you, I'll make one, at the top of this pyramid, I'll denote something to be called as grand norm. Grand norm. Okay. You can denote it to be called as supreme law or supreme norm. Okay. Supreme law. Okay. And below this we have other laws or other norms. Okay. Now Hans Kelsen introduced this theory, that was pure theory of law. He said there is one law which is grand norm, which is above every law, that is to be called as supreme law, and all the other laws in that place have to abide with this grand norm, and they cannot be violative of this grand norm. Okay. And if they are found to be violative of this grand norm, they are to be declared to be void. Now let's apply this concept to our India. Okay. In India, constitution is grand norm. Grand norm. Okay. That means on the top of this pyramid we have constitution, and below which we have all the other laws passed by legislation, either it is state legislation or either it is union legislation. And also we have something which is called as rules, which are made by executives, right? Now these rules cannot violate constitution. These other laws which are made by legislation also cannot violate constitution, because this constitution is grand norm. Okay. This is supreme law which is made. Okay. Now let's come back to this point. What I said was, sovereignty binds society by making this supreme law, and in India this supreme law is constitution. Okay. And sovereignty always takes away rights. Okay. Takes away certain rights. Okay. Takes away certain rights, and by taking away that certain rights, it ensures certain things also. That is, we will ensure something which is security of liberty. Okay. we will ensure something that is security of your life. Okay, we will ensure that there will be a stable society where you can live, you can seek justice and all. Okay, so this is the constitution, that is the supreme law we have made here, and all the other laws has to abide with this constitution. That is the supreme law of this land. So till now we have understood one, that was the development of law which happens in society. This was the first point we understood. And second, from society, when I added sovereignty, we reached towards state, definition of state, which is according to international law. International law. Okay. Now, the third thing we understood, that there is something which is called as pure theory of law, that is our grand norm. Grand norm. And all other laws has to abide with this grand norm. The next thing which we are going to understand here is that we understood in constitution, the constitution is grand norm. Now let us understand what was the status of these other laws in front of constitution. Okay. So law can be divided in two stages, that is, one can be said as pre-constitutional laws which we have in our country, pre-constitutional law. One can be termed as post-constitutional law, constitutional law. One which can be termed as pre-constitutional law, one which can be termed as post-constitutional law. Okay. Now, what is pre-constitutional law? What is post-constitutional law? Let us understand by understanding first what is law. Okay. Now, here I am going to take the base of constitution because this is the supreme law we are having. And constitution itself have defined what will be called as law under Article 3A of the constitution. We have a list which will be termed to be called as law. Okay. What is this list contains? See. In constitution under Article 13(3)(a), we have this list. In that list, 8 things are mentioned. 8 things are mentioned which will be termed as law according to constitution, which will be treated to be called as law. Okay. What are these 8 things? According to Article 13(3)(a), the first thing is ordinance. Ordinance. Okay. Now what is this ordinance? Ordinance is the law which is issued by either president or either governor of the state in the absence of parliament in session. Okay. Now this ordinance, as I said, under Article 123, president passed the ordinance, and under Article 213, governor passes this ordinance. And this ordinance will be treated as law under constitution, which is given under Article 13(3)(a). The second thing is order. Okay. By order I am meaning public order, not private order, public order, which are the order for general in for the public. Okay. So according to Article 13(3)(a), it will be treated as law. Then there are certain bylaws. Okay. That is rules made by authorities under delegated powers. So these are certain rules made by authorities under their respective delegated powers. Then fourth thing which is given under your Article 13(3)(a) is rules. Rules are certain guidelines. Rules which are certain guidelines. Then fifth is regulation. Regulation. They are certain directives. Okay. We usually take this two together, that are rules and regulations. Together we use this. Then we have sixth thing, that are notification. Notification. Okay. Anything which is published on official gazette. Official gazette. Okay. For example, the notification is how much important you will know by this example. There was one case in Supreme Court. Okay. Regarding some law, regarding some act. It was found that that act was never published on official gazette. What is this official gazette? That is Gazette of India. Official Gazette of India. Okay. So any act or any law in this country, if it is not published on the official Gazette of India, it will never be said to be enforced. Okay. It will never be said to be enforced. So that case was The particular act was never published on official Gazette of India. So hence, when the matter relating to that act came, it was said that that act was never existed. So hence, any matter under that act is not applicable. Okay. So that is the relevance of this official Gazette of India. Then seventh thing which is given in under Article 13(3)(a) to be called as law is custom. Okay. Anything which is custom followed by people over a period of time. Then eighth thing is usage. So these are the 8 things which is under Article 13(3)(a) is considered to be as law, is considered to be called as law. Okay. Now what is these 8 things together can be called as, these 8 things together can be called as the force of law. The force of law. Now again I'll take this chart here. I was discussing with you about law. Okay. I discussed with you Article 13 clause 3 subclause A. Okay. In constitution, how we mention article, then we mention it clause, then we mention it sub clause, right? Likewise we mention. So we discussed Article 13(3)(a) to understand what is law according to constitution. 8 things are there which we discussed. Now in the chart I denoted 2 things. One is pre-constitutional law, constitutional law, and second thing which I referred was post-constitutional law. Pre-constitutional law and post-constitutional law. For this I denoted it to be as the force of law. Force of law. Pre-constitutional law, those laws which was in existence before the constitution came into existence. In simple words, when did the constitution came into existence? See, it was prepared on the final draft was there available on 26th November 1949 and it was enforced. The commencement was 26th January 1950. So any law to be called as pre-constitutional law, that law existed before this date 26th January 1950. The law which was in existence or before the constitution. For example, there are several examples. For example, Contract Act. It was enforced on 1st September 1872. Similarly, Evidence Act. Evidence Act. We had this act also on the same date, that was 1st September of 1872. Okay, see, these all acts are 100 years older than the constitution. We refer them to be called as pre-constitutional law. And the term we use for this pre-constitutional law is law in force. Law in force. That means those law which was there before the constitution was there in existence and remains in existence after the constitution came in existence, we term them as law in force. Okay. And for the other things, the 8 things which we term as law, for them we use this term, that is the force of law. Okay. Now again I will continue with the explanation of Article 13. Okay. So here we understood under Article 13(3)(a) there are 8 things. They will be the force of law. Force of law. Okay. In similarly, there in Article 13(3)(b) we have this law in force. Okay. Law in force. We just understood what is law in force. Those laws which are pre-constitutional laws. Okay. So under Article 13(3)(b) we have law in force. So now we will relate one more article along with this, that is Article 372, which provides for continuance in force of existing laws and their adaptation. By this article, that is Article 372, we get the continuance, of those existing law. And there are 2 explanations who can amend this particular laws which are there in pre-constitution phase. 2 parties, the 2 authorities can amend this, which is provided in explanation 1 of this Article 372. That is, the Parliament can amend in the pre-constitutional laws okay, which we will term at to a term to be called as law in force. And the second, any competent authority. Competent authority. Okay. The parliament can amend in what? In pre-constitutional law, and the competent authority can amend in what? Pre-constitutional law. Okay, that is law in force. Those laws which was there in existence before the constitution was in existence. Okay. Now, the parliament can amend in those pre-constitutional law, and the competent authority can amend the pre-constitutional law. And what are these competent authority? Four things are to be called as competent authority. One, of course, your parliament is competent authority. It will continue here. Parliament, and president is a competent authority here under article 123. Okay, he can issue ordinance, and by that ordinance he can also do the change in any amendment in pre-constitutional laws. Then we have state legislature as competent authority, and governor. So these are the four bodies who is termed to be called as competent authority, who can amend in pre-constitutional laws. Pre-constitutional laws. Okay. So what we understood here? We understood that in understanding laws, we understood under article 13(3)(a) we have force of law. Force of law. Under article 13(3)(b) we have law in force. Law in force, that is pre-constitutional laws. Okay, and we have, then other thing we have is post-constitutional laws. Constitutional laws. See here, I introduced a while ago to you that was pure theory of law. What was that pure theory of law? Was that any law, either it is pre-constitutional law or it is post-constitutional law, cannot violate that is constitution. Okay, if it violates constitutional, it will be struck down and will be declared to be as unconstitutional. Will be declared to be as unconstitutional. Okay. So I hope till now this much is clear to you. Okay. To understand this document of law, that is constitution, we went with the understanding of these philosophies. That was what is pre-constitution, what is post-constitutional laws, what is state, what is society, what is law in general. Okay, article 13(3)(a) and all. Now let us understand with our second concept, that is what are the types of constitution. Types of constitution. What are the different types of constitutions are there? Okay, now before coming to this point of types of constitution, I would like to take the attendance of the participants. Are you there?